everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today is the day I earn that subscription. For today's story, we are turning to Arizona and the governor's race. Keri Lake was a candidate for governor running on the Republican ticket, and she lost the election by about 17,000 votes. But there were some complications because Arizona had many problems with its election, not the least of which was the actual counting, which took forever. It took a very long time to count votes. And then it turned out that there were problems on election day. There were problems with the machines, printing on the wrong size paper, 20-inch balance printed on 19-inch paper, or maybe the other way around. I forget. Whatever. And also that there were problems with the ink and also problems with other things that caused issues that might have caused people to not vote because the lines got long. Because, it was too difficult to vote. People had to go to work. People had to pick up their kids, whatever, right? And so some people might not have voted due to some of this election day chaos. And the numbers seem to suggest there was enough election day chaos that it could have very well flipped the election for Keri Lake. So Keri Lake sued, saying, all this election day stuff interfered with my being elected, which should have occurred, but for the stuff. Well, the judge said basically, yeah, maybe there was some stuff, but you have to prove intentionality. It's not just enough that stuff goes wrong, because stuff always goes wrong. We live in a chaotic world, right? Things go wrong all the time. If the standard was something went wrong, we'd never be able to have any finality. So it's not just enough to be able to show something went wrong. You have to show that someone did it deliberately. Someone intentionally messed with the machines or whatever that caused this problem, right? It's not enough that they just screwed up at their job because it's the government. Of course they screwed up at their job, right? You have to show that someone did it with malice. You have to show that someone did it purposefully for the purpose, and that, of course, that ultimately that purpose also manifested in a difference. So, of course, it's not enough that they just did a bad thing. The bad thing would have also had to matter. In any case, the judge has issued a decision and said not so much. And so we're going to go through this decision, which was just ordered about an hour ago, I guess. And we're going to go through this decision and go through the judge's reasoning and try to discuss what was happening. So let's get started with this. Okay. This court has considered the evidence presented at the evidentiary hearing on December the 21st and 22nd, including all exhibits admitted as well as testimony of the witnesses. The court has read and considered 220 affidavits attached to the verified petition. The court has also considered arguments by counsel. The court accordingly issues the following findings of fact and conclusions of law. Legal standards and burden of proof. So that's a pretty good place to start, right? What is the standard we are trying to reach, right? We can't decide whether there's a problem unless we decide to what degree do we have to prove the problem. What level of confidence do we need? And this is not, of course, an unknown concept in law. Different levels of things requires different levels of confidence, right? You've heard about preponderance of the evidence in a typical civil standard. There's also clear and convincing evidence that sometimes applies in civil standards, beyond a reasonable doubt in criminal standards, and sometimes you even see a few standards beyond that. But there are different standards. There are different burdens of proof. What evidence do we have to present? How sure do we have to be? What are the questions we're supposed to ask? These are good things to know. So here's what apparently the judge thinks is the legal standard. Throughout the history of Arizona, the bar to overturn an election on grounds of misconduct in the state or territory has always been high. It is the objective of elections to ascertain a free expression of the will of the voters, and no mere irregularity can be considered unless it be shown that the result has been affected by such irregularity. And the problem there is that irregularities happen kind of all the time. Because things go wrong. We live in the real world. And perfection is difficult, if not impossible. Especially when you're trying to get 2.5 million people's votes counted. Right? So mere irregularity isn't going to really cut it as a general rule. Okay. Our territorial Supreme Court, so before we were a state, our territorial Supreme Court said in 1898 that it is unwise to lay down any rule by which the certainty and accuracy of an election may be jeopardized by the reliance upon any proof affecting such results that is not of the most clear and conclusive character. Clear and conclusive, that sounds like a standard, like clear and convincing or preponderance of the evidence. That sounds like a standard. That sounds like an elevated standard. Clear and conclusive. Okay. The official election returns are prima facie evidence of votes actually cast. That much is clear by law. The burden of proof in election contest is on the challenger, which makes sense. The duty of specifying and pointing out alleged irregularities and insufficiencies is a task that should be undertaken by litigants and counsel. Right, so if you're the one trying to challenge the results, it's on you to provide the proof, right? We have a system in place. The system has done a thing. If you say the system is screwed up in some sort of way, it's on you to provide that evidence. It's on you to change the status quo, right? This is kind of just generally true in law. If you want like one principle that applies, right? If you want to change the status quo, it's your burden, right? So whatever the current governing reality is, you're the one who has to change it, right? The degree to which you have to change, or the degree of certainty to which you're required to prove the change, is up in the air, right? So there's different levels, but it's always on you if you want to change it, right? This is, for example, why at a criminal trial, we talk about proof beyond a reasonable doubt at the trial stage, right? Innocent until proven guilty. But then on appeal, we're like, well, innocent until proven guilty is over now. That happened because only the defendant can appeal a criminal case, right? Innocent until proven guilty is over now. That happened. Guilty is now the baseline reality. Guilty is now the assumption. And so all the things are going to be read in that light. Just as before at trial, they were read in the light of the opposite, because the opposite was the presumption, right? Going in at trial, innocent, right? So all things are filtered through that light. Then on appeal, guilty. So all things are filtered through that light, right? And this is true in the civil system too, right? If you want to change something, like, you're fighting a contract or fighting a debt or something, it's on the person who's trying to change the reality. And then if there's an appeal, it's on the other person, depending on who won and who lost. So this is kind of always true. It's always on the person challenging. And to do this, you've got to present evidence. And how confident do we need that evidence depends on the thing that you're trying to do. That is just true as a matter of generalized principles of law. So fair enough. As for the actions of election officials themselves, this court must presume good faith of their official conduct as a matter of law. All reasonable presumptions must favor the validity of election. Election challengers must prove the evidence by clear and convincing evidence. This is kind of true just sort of as a start, right? The good faith of the election officials, they're the ones being sued. So in the event of a tie, they would always win, right? Because you can't win on a tie. You need something more than a tie. So the presumption is always in favor of the defendant. How strong that presumption is a matter of some dispute. But we're going to presume they're in the right. It's up to you changing the status quo. And in this case, we're going to need clear and convincing evidence. So mere preponderance of the evidence won't do. We need clear and convincing evidence. Okay. The order granting in part defendant's motion to dismiss gave plaintiff two independent claims for seeking relief requested. Plaintiff has only these options because election contests are purely statutory and depend upon statutory provisions for their conduct. Correct, right? That we should have elections might be a constitutional thing, but as to how they're operated, statute. Put it another way, plaintiff has no freestanding right to challenge election results based on what plaintiff believes rightly or wrongly went awry on election day. She must prove as a matter of law, prove a ground the legislature has provided for as a basis for challenge. It's up to the legislature to create the statutes, and it's up to the court to interpret the statutes. This is the different roles of the different levels of government. The legislature has created election procedures that were voted on and adopted through a lawful process. So that is the statute now. The court's job, especially if you're a conservative, particularly if you're a conservative, is to apply what the legislature said, right? That's what a good judge does. A good judge interprets law. They don't create law, right? They might have to create a new interpretation. They might have to deal with a novel question, but it's the legislature that deals with it in the first place as a matter of policy. Legislatures do policy. Courts do law, right? So as to what should be, talk to the legislature. As to what is, talk to a court. So if you want to challenge this procedure in the statute, they're the ones that created it. They're the one you need to attack it using that mechanism, the mechanisms that are there, because this is a statutory process. So yeah, you just can't create something out of nothing, which is a very conservative thing to do. The remedy may not be extended to include cases not within the language or intent of the legislative act. That's a strict constructionist. Go to the statute. What does it say? Failure of a contestant of an election to strictly comply is fatal. Fair enough. It's the legislature who gives you a remedy. Go do that. Plaintiffs' remaining claims are based upon the following statutory ground: misconduct on the part of an election board or any members thereof, any of the conducts of the state, or on any part or officer or participating in the canvass for election. And then we have that critical word, misconduct. Misconduct is a critical word in that sentence, right? Misconduct on the part of election boards, which implies some sort of malice, right? It implies some sort of corruption, misconduct. The trial was premised on plaintiff's theory arising from a second clause concerning an officer's making or participating in a canvass. The order permitting the two counts to proceed to trial, the claim that the ballot on demand printer malfunctions experienced on election day were caused intentionally, and these elections changed the count outcome, and the claim that Maricopa County violated its own election manual as to chain of custody procedures in such a way as to result to change outcome. As outlined in the order partially granting the motion dismissed, there are 4 elements to the claim. Plaintiff needs to prove by clear and convincing evidence each element. Again, this is pretty standard law, right? Whatever the burden of proof is, it applies to each and every element of the claim, right? A criminal statute, for example, usually has multiple different parts. It is up to the prosecutor by proof beyond a reasonable doubt in a criminal case to prove each and every element. If you don't prove each and every element of the criminal charge, then not guilty. If you do, then guilty. So yes, whatever the burden of proof is, it would be expected that burden of proof would be consistent as to every element. Now, sometimes you do see certain elements that have to be proven to a different standard than other elements. For example, we saw that in the Johnny Depp case, where most of the elements were preponderance of the evidence, but actual malice, clear and convincing. So sometimes you do get a separation, but because that's the way the laws define those things. But, whatever your burden of proof is, there's a burden of proof as to each element, and you got to meet your standard. So, fair enough. Thank you very much, Saint Dionysius, for 50 gift memberships. That is very, very thoughtful of you. Thank you very, very much for your 50 gift memberships, and Merry, Merry Christmas to each and all of you. Thank you very much. So here are the 4 elements that you need to prove. That the alleged misconduct, whether the ballot on demand printer irregularities or ostensible failure to abide by election procedures, was intentional. That would be that kind of misconduct idea. That the misconduct was an intentional act conducted by a person covered by statute, that is, an officer making or participating in a canvass. That the misconduct was intended to change the result of the election, and that it did change the result of the election. So they were doing the bad thing for a corrupt purpose and achieved their corrupt purpose. That is the thing that we're trying to prove. It bears mentioning that because of the requested remedy, setting aside the result of the election, the question before the court is of monumental importance to every voter. Yeah, that too. That too. And to some degree, this makes total logical sense because, like, the more that you're asking, the higher your standard should be, right? If you're trying to put someone in jail for the rest of their life, the standard should be really high. If you're trying to overturn an election and change who's going to be the governing official, the governor in particular, the standard should be high because you're asking for a lot. So sometimes you're asking for not as much. Sometimes you're asking for much more. So the degree of evidence that you need somewhat does and somewhat should scale with the ask. And you are asking for either the court to just declare the other person is the governor-elect, or to order a completely new election with what time, one wonders. Either way, you're asking for a lot. So we're going to demand a lot, which makes total sense. You don't want a court ordering a dramatic remedy without somewhat dramatic proof. Exceptional claims demand exceptional evidence is the kind of idea, which seems logical. Mika Fan asks, would I prefer membership here or locals? If you're gifting memberships, then here, I suppose, because gifted memberships hopefully encourage those people, or at least some of those people, to renew their memberships. So that's one of the benefits of gifted memberships, is that hopefully some of them will convert and become paid members as well. So but however you choose to gift is fine. Was this decided yesterday? No, this was decided today. The court issued its decision about an hour ago. The margin of victory as reported by the official canvass is 17,117 votes, beyond the scope of a statutory required recount. A court setting such a margin aside, as far as the court is able to determine, has never been done in the history of the United States. This challenge also comes after a hotly contested gubernatorial race and ongoing tumult over election procedures and legitimacy, a far less uncommon occurrence in the country. This court acknowledges the anger and frustration of voters who were subjected to inconvenience and confusion at voter centers as technical problems arose during the 2022 election. But this court's duty is not solely to incline an ear to public outcry. Damn right? Law should not be done by mob, right? Just because a lot of people are angry does not imply the court should do something about it, right? If we did law by mob, we'd be a much worse society. It is subject to plaintiff's claims and defendant's actions to the light of the courtroom and scrutiny of law. It is the boast of American democracy that it's a government of law and not of men, and so the court begins with review of the evidence. Okay, so we set out our standard. Our standard appears to be well set out in law, appears to go back to when Arizona was a territory, which wasn't that long ago, and says, okay, we need clear and convincing evidence which makes total logical sense. And the court notes here that the difference between the two candidates is higher than the mandatory recount provided by law, and the ask is really big, and you're asking the court to do a lot, and so the court is going to be conservative, small c conservative, right? It's like, prove it, bring it. So okay, that makes total logical sense. It was plaintiff's burden to establish each and every element by clear and convincing evidence. Fair enough. If plaintiff herself failed to sustain the burden of proof, the matter is decided. Correct. If you don't make your burden, you lose. That's kind of true no matter what kind of law you're doing. You have a burden, and if you can't make it, you lose. All right, so let's look over some of the evidence. The court first considers Mark Sonenclair. Sonenclair. The court first considers Mark Sonenclair, a roving election attorney with the Republican National Committee. Mark testified that on election day, he went from polling location to polling location, speaking with partisan observers. Mark first visited 8 centers on election day. He testified to his personal knowledge of failure of tabulators at multiple locations to accept ballots, his own personal estimates of rate of failure, the efforts of varying degrees of efficacy of Maricopa County techs to fix the tabulators, the frustration and anger of voters who had to wait in longer line due to failures. He testified that the county provided wait times were not accurate and that a much higher number of voter centers suffered from these failures than was admitted by the county. The court credits the personal observations of Mark and does not doubt his knowledge or his veracity. But the court cannot follow Mark to ascribe intentional misconduct to each party, which, he saw some things go wrong, but he doesn't know why, right? He sees these problems, but he doesn't know why they're happening. Mark said at trial that it was common sense that such widespread failures must have been the result of intentional conduct, but this intuition does not square with Mark's own observations. For one thing, county techs being sent to troubleshoot and fix issues with the tabulators are not consistent with a scheme by a person or persons to affect the results. So that might be some evidence that might suggest non-intentionality. They were dispatching people to try to fix the problems. Second, as Mark himself admitted, he did not personally observe anything that allowed him to support his intuition that someone had engaged in intentional misconduct. Third, Mark admitted that he had no technical knowledge, which will allow him to infer that these ostensible technical failures were anything but malfunctions rather than malfeasance. And that's the thing we're trying to prove is malfeasance. Ignorance of the law is fine if our side wins from it. I don't know what you're talking about, Waffleganger. No one is arguing about ignorance of the law. I don't know what you mean. This has no, no one's talking about ignorance of the law. No one's argued ignorance of the law. I don't know what you're talking about. Last, Mark admitted that he had no personal knowledge of any voter being turned away from the polls as a result of the ballot on demand failures. As far as misconduct is concerned, the court finds nothing to substantiate plaintiff's claims of intentional misconduct as to either claim through Mark's testimony. And, fair enough. He is a roving election observer on behalf of the RNC. And what he sees is problems on election day. He sees machines failing. He sees the ballot on demand machines failing. He says the lines are longer than the county is saying they were. He's saying that these problems existed at multiple different places. So, he's observing that there are problems, but nothing he's observing as to why. Nothing he's observing is going to why this was occurring. And he can't prove from his observations that things happened that this was due to malfeasance as opposed to technical problems. Which, fair enough. I mean, that's speculative. It's speculative. So he says, well, it makes sense to me, and maybe it does make sense, but it's a speculative conclusion. So it's not an irrational conclusion. It's not an irrational conclusion. It's just not the only conclusion, nor is it a conclusion we can draw with clear and convincing evidence, because we don't really have any evidence that would go to people's intent. As to that witness. All right, next witness. The court next considers Heather Honey, a supply chain auditor and consultant who testified primarily concerning chain of custody. The court again credits Honey's observations and personal knowledge of the system of early voting ballots. As relevant to misconduct, her testimony makes 2 points. Maricopa County did not produce, pursuant to public acts requests, Maricopa County delivery receipt forms for ballot packets dropped off by voters at drop boxes. And then an employee of Rubik Election Services averred, which is the same thing as saying offered, that Rubnik employees were permitted to submit about 50 ballot packs of family and friends into the ballot stream improperly. Again, this court does not denote Honey's veracity, but her testimony is of limited use in making a finding that intentional misconduct occurred. For one thing, Honey agrees during her cross-examination that, while she has not received the Maricopa County delivery receipt forms, she knows that these forms, in fact, do exist. While she testified the public records request has not yet been fulfilled, To the extent there is a claim made for insufficient production by the county in response to the public records request, that claim is not before the court. So whether or not they complied with their state equivalent of FOIA is not the issue right now. Because the plaintiff expert agrees the forms which these bases were generated, plaintiff cannot point to their absent writ large as a violation of the manual. So the problem, the thing is that the forms do exist. She hasn't been provided with them, according to the plaintiff's expert, right? So these forms have to exist, according to the law. Plaintiff's expert says the forms exist. We just don't have them. They haven't produced them, pursuant to FOIA. So the problem isn't the forms existing, which would be an election problem. The problem is the forms haven't been produced responsive to FOIA, which is a FOIA problem, right? Different part of law, different problem. If the forms didn't exist, election problem, or at least election procedure manual problem. But the plaintiff says they exist. We just don't have them. So it's not an election procedure manual problem. It's a FOIA problem. This court isn't here to solve the FOIA problem right now. So, yeah. Zombie says, why should it matter? Why should intent matter if wrongdoing did in fact cause damage? Well, because as a practical matter, you would never have an election. You could never have an election that's perfect. Basically, why? Like, if you were able to overturn any election for any problem that occurred, you'd never be able to have an election. It's just impossible. You are dealing with, especially on a statewide race, you are dealing with, 80 different counties, each county of which has, however many different voting centers that are voting on different days with different people on different days that are there and doing different things. And why do you need intentionality? Because if you could do this on like a mere negligence standard or a mere something went wrong standard, you never be able to have an election. Because the alternative is perfection, and perfection is impossible. So the problem was not statewide, it was Maricopa wide. Well, first of all, you don't know that. It might have been statewide. Second of all, even if it's Maricopa wide, Maricopa is where most of the voters is, so it's kind of the same problem. So if you say, okay, it's Maricopa wide, not statewide, it's kind of the exact same problem because most of the voters are there. So that's why you would never be able to get anything done. It's not impossible to rule is a serious issue and affect enough voters to shift the election. If you can define what serious is, what makes an issue serious? How do you define that? What is the standard for determining seriousness? It can't be whether it affected the election, because that, according to you, is the second standard. So what defines seriousness in the abstract? But anyways, I'm digressing. You can see the problems. Hopefully. Next, as to the 50 ballot packets, Miss Honey admitted that neither she nor her contacts with Rubik had personal knowledge of any permission given by Maricopa County to Runbeck. Would you say losing chain of custody on your largest county altogether sounds serious? I don't know. Any loss of chain of custody of one ballot? Again, what is the standard for seriousness here? Would I say that losing chain of custody is inherently serious? I don't know. How am I measuring it? If one ballot went wrong in terms of a chain of custody, is that enough for it to be a serious issue? Or is it 100? Or is it 1,000? What's the standard for seriousness? I don't know. You tell me. Serious means preventing a voter from voting. So one voter is your standard for serious. Preventing a voter from voting. So in that reality, you could never have an election. If your standard is it prevents a voter from voting, you'd never be able to have an election. One voter gets to the precinct and there's a line and decides to walk away. That's a voter who's prevented from voting. Your standard is completely unworkable. Is one ballot with no chain of custody against the law? Probably. Is that the same thing as being a serious issue? I feel like you're not thinking these things through. I shouldn't have to really help you think this through. Think it through. Before you propose something, think it through. Think what that would really mean. Think what would happen if you really did that. What would that really mean? How would that really work? Think it through. You can do it. I believe in you. The court must also consider affidavits by Leslie White and Denise Marie on this point. The White affidavit, and also incidentally, you're going to want to make sure that that applies to both parties and make sure that you're happy with that standard being applied universally. So think it through, get back. Thank you for sharing my stream. That's very nice. The court also must consider the affidavits by Leslie White and Denise Marie on this point. The White affidavit is less helpful on these points, as Ms. White testifies mainly to the limitations of what she was allowed to see as an observer of Maricopa County Tabulation Election Center. She expresses worry over the rapid pace of processes at the election center, objects to the limited field of view as an observer, but does not point to any violation of the manual, nor does counsel draw his attention to any violation. So she might not have been able to see as much as she likes, but it was consistent with the manual, so it's not a legal problem. You're building the biggest straw man I've ever seen? No, I'm not. I'm really not, Guac. I'm not building a straw man. I am literally responding to what the argument was. That's not a straw man. That's just responding to what it was. The comment was, the standard is if it affects the outcome of the election. At all? To any degree? And first of all, that can't be the standard because that was part 2 of the proposed standard. The proposed standard was seriousness and that it impacts the election. So that it impacts the election can't be what defines it to be serious, because then that would make 2-part standard a 1-part standard, and then that wasn't the proposal. So it can't be that, because that defies the 2-part standard. The second thing was that serious, from Timothy, said preventing a voter from voting. That's not me strawmanning. That was the proposal. And I'm like, really? A voter, 1 voter. Here's what that would mean. ... That's not straw man. That was the proposal. I'm just taking the proposal and applying it logically. I think you need help learning what a straw man is. Straw man is where I take an argument and replace it with a weaker version of the same argument. Straw man isn't where I take a weak argument and apply it logically. Straw man. Settle down? Someone accused... No, first of all, no, I won't. I don't think I will, a little drama for mama. I don't think I will settle down. First of all, it's my channel. I'll do whatever the hell I want. Second of all, someone said that I was setting up a straw man. No, I'm not. Here's why I'm not. This was the proposal. A voter. Okay, I accept your premise. A voter, 1. Well, that's a straw man. No, that's the proposal. As for Miss Marie's affidavit, the court must weigh her averment that family ballots were inserted into the ballot stream in violation of the manual and chain of custody requirements against the sworn testimony of both Miss Valenzuela and Mr. Jarrett, who testified that Maricopa County employees who follow the manual have eyes on the ballot process during their time at Runbeck. The court finds the latter more credible, given that Miss Marie does not allege anything about Maricopa County's roles in this violation. The combined testimony of multiple officers concerning training of employees and lack of authorization for such a violation, and given the purported authorization for such practice is hearsay within the affidavit, the court cannot therefore afford the document weight, which, fair enough. You can't respond to what other people have heard in your own affidavit. That's not fair. Thank you, Dark Avenger. I appreciate that. In closing, counsel for plaintiff argues it doesn't make much sense that Maricopa County did not know how many ballots Maricopa County had received on election night. But at trial, it was not Maricopa County's burden to establish its process or process was reasonable, or that it had an accurate unofficial count on election night. Even if the county did bear that burden, failing to carry it would not be enough to set aside the election. Particularly where plaintiff's own witness on this point lacked personal knowledge of intent, admits the defendant did in fact generate the documents that they were required to, and otherwise affirms the county's compliance with the election process. The court cannot say the plaintiff proved element one of the count by clear and convincing evidence. So kind of the same thing, right? We see some problems, but we have some counter testimony. The judge found the counter testimony to be credible because of the presumptions by law, right? We are supposed to presume that those people are acting within good faith by law. So we're supposed to assume that they're telling the truth. We got two of them who said this is the reality. So I got one witness who's testifying to some stuff, and I got two other witnesses who are election officials testifying to stuff. The law says I'm supposed to give them the benefit of the doubt, so they're therefore more credible. That is a logical conclusion. Yeah. So let's look at Clay Parikh. Parikh. Clay has an impressive technical background as a cybersecurity expert for Northrop Grumman. The court again credits his substantial experience and personal knowledge as far as it goes. The primary contention was that printer errors he saw reflected in this ballot review he conducted by printing of 19-inch ballot on 20-inch paper. Thank you for becoming a level 2 member, Bazooka Badger. That's very kind of you. Must have been done intentionally, either by overriding the image file that was sent from the laptop to the printer, or from the ballot image definition side. However, if the ballot definitions were changed, it stands to reason that every ballot for that particular definition printed on every machine, so it would effectively be printed incorrectly. I mean, that is pretty logical. If the machine was set wrong, it would be logical that they were all wrong. So that would be, yeah. As the plaintiff's next witness indicates, this was not the case. So that seems wrong. Like if the setting was wrong, then they'd be wrong on every single ballot because the machine would just be doing it wrong every single time. But it wasn't wrong every single time. So that seems like, yeah. In either event, Clay acknowledged he had no personal knowledge of any intent behind the error. That too. So he observed some ballots being wrong. Court notes it doesn't make sense that it's technical because presumably that would affect all the ballots, and it didn't. And also, even if it did, we have no knowledge of intent. So that's okay. The court notes that Clay also acknowledged a fact admitted by several of plaintiff's witnesses, that any ballot that could not be read due to a printer or tabulator failure could be submitted for ballot duplication and adjudication through door 3 of the tabulators. Plaintiff's own expert acknowledged that a ballot that was unable to be read at a vote center could be deposited by a voter, duplicated by the ballot partisan board on a readable ballot, and in the final analysis counted. Thus, plaintiff's expert on this point admitted that voters who suffered from the tabulator rejections would nevertheless have their votes counted. This did seem to be true. So the ballots may have not been able to be counted through the initial process, but there was a process to rectify those ballots. And those ballots were in fact rectified. And also, incidentally, they probably didn't affect any votes on election day because the voter wouldn't notice. They would just be put into the machine. And so it probably didn't impact any votes anyway. This means at a minimum, the actual impact element could not be proven. The printer failures did not affect results of this election. Further, as to intent elements, the court must pair its consideration of Clay's testimony without another witness. David Benecourt was a temporary employee of Maricopa County, called by plaintiff to testify to technical issues on the day. These technical people, in addition to setting up voting centers, provide technical support on election day. As relevant here, David testified that there were, in fact, multiple technical issues experienced on election day. He testified that they were solved by means such as taking out toner and/or ink cartridges and shaking them, cleaning the corona wire, letting the printers warm up, cleaning the tabulators, and adjusting settings on the printer. It's of note, apart from 5, none of these simple solutions implicate the ballot in a manner suggesting intent. Mr. Benecourt testified that each of these on-site actions were successful to varying degrees, with shaking the toner cartridge being the most effective. It's worth repeating that the ballots that could not be read by a tabulator immediately, because of printer settings or anything else, could be deposited in door 3 and counted after duplication by the bipartisan board. Mr. Benecourt testified that not only did he lack knowledge of any technical person or anyone else engaging in intentional misconduct, but further testified the techs he worked with diligently and expeditiously troubleshot each problem that arose, and they did so in a frenetic election day environment. Plaintiff's own witnesses testified to the court that ballot-on-demand printer failures were largely the result of unforeseen mechanical failures. A little drama from Mama says, isn't there a standard called gross negligence? Yes, there is a standard called gross negligence. It's effectively the same thing as recklessness. Gross negligence. There can be some minor differences depending on the state and depending on the jurisdiction, but as a general proposition, gross negligence, you can just think recklessness, right? Negligent, and the difference, of course, the difference between negligence and recklessness, if you want a short definition, is negligence is just not performing your duty as well as you could. Recklessness is behaving in such a way that something was going to go wrong, right? So if you want an example from like a practical life, right? If you want something from a practical life, right? If you're driving a car and you hit the guy who's in front of you, stopped at the stoplight, right? That's negligence, right? You weren't paying sufficient attention, or you didn't apply the brakes in time, or your car wasn't in mechanical condition, which incidentally is also on you since you're the owner of the car. So that would be simple negligence, right? You have a duty to not hit the guy, stop at the stoplight, and run into the back of him. You did from some failure, right? But that doesn't imply recklessness. Recklessness is something you were behaving in a completely brazen way. So example would be speeding and swerving through traffic, right? You're speeding and changing lanes a lot and stuff like that. It's like you're behaving in a way that something's going to go wrong eventually. We're not sure exactly when or what it will be, right? But eventually this is going to catch up with you. But yeah, that's basically the difference between reckless/gross negligence and regular negligence, if you like. It's like someone did a thing that just showed that they weren't paying attention. It's the difference between not paying attention and it's the difference between awareness and not, I guess. It's the difference between awareness that you are doing something versus non-awareness or distraction. Something like that. Thank you for the question. So next, as to Richard, couldn't gross negligence be considered intent? No. The hierarchy, if you want the hierarchy that we normally think of in these things: intent, knowledge, reckless, negligent. Intent is the highest thing. Gross negligence, recklessness. It's usually intent, knowledge, reckless, negligent is the order. So no, but thank you again for your question. Ms. Barris testified that as a director of Big Data Poll, he testified that as a result of the ballot-on-demand printer's failure of Election Day, that a number of voters were disenfranchised. Knowledge of an issue and failure to fix it is not intent. No, not necessarily. No, in fact, probably very unlikely. It would be like, what would be a good example from your life? Again, we could go to like driving as an example because it's something people do every day. It would be like, what would be a good example? It would be like, okay, it would be like you go to the shop to have your car inspected, and the shop tells you your tires are at the legal minimum, right? So they're barely they're at the legal minimum of tread depth. Okay. So, these tires are going to expand. These tires are on their very, very last legs, right? And you're like, but I don't want to change them. And the tire shop's like, but they're at the legal minimum. And you're like, yes, they're at the legal minimum, which means they're legal. So release my car to me. And they're like, okay. So does that imply that, so now you have knowledge that your tires are on death's door, and so then you drive another 1,000 miles? Does this imply that any accident you get into now is now an intentional accident, that you meant for that to happen? No, right? The knowledge might go to recklessness, maybe, but like it doesn't imply intentionality. It implies that you're a dipshit. So no, mere knowledge of a problem doesn't necessarily imply intentionality. Those are different. But thank you for your question. This is good. This is good legal education, right? So it's like, yeah, this is good ways to differentiate these things. I can guarantee you, yes, it implies that, because I can also guarantee that your insurance will sue you if they have knowledge of that. No, it really doesn't. No. And also, your insurance company doesn't need to prove intent to win. Right. I mean, they don't need to prove intent. So your insurance company very well might sue you or refuse to pay out. But that doesn't prove intent, because that isn't the standard. Right. That's a failure on your part. It's a knowing failure on your part. So you don't have to prove intentionality as the insurance company to refuse to pay out. I mean, it would help, but it's not required. So your insurance company may refuse to pay out, and your insurance company may sue you. It doesn't prove intent. Intent is design. Intent is design. It's the thing you were trying to do. Right. That's, yeah. The judge hasn't made a ruling yet. So what am I talking about? The judge has literally made a ruling. Erica, I'm literally reading the ruling as we speak. The judge has in fact made a ruling. The judge is in fact back. He made a ruling about an hour ago. We're reading it. Continuing on. No decision's been made yet? Then what am I reading, Erica? What am I reading? I don't know. It looks like a ruling. It's ordered confirming the election of Katie Hobbs as the Arizona governor elect. I don't know. That looks like a decision to my mind, but I guess I could be wrong. Okay. Somehow. The judge hasn't made his decision yet. Erica, what are you talking about? What? Where was I? This is the strangest troll I've seen yet. This is the strangest roll I've seen yet. Okay, I guess you guys can continue to argue in the chat about whether or not the decision I'm reading has been decided or not. Furthermore, Ms. Barris testified at trial that no one can give a specific number of voters who are put off from voting on election day. Thus, even if plaintiff proved elements 1 through 3 of count 2 by clear and convincing evidence, the truth of the statement alone dooms element 4. No election in Arizona has ever been set aside, no result modified because of a statistical estimate. In the court's view, it's a quantum leap to go from analogizing cases where malfeasance was precisely quantified, such that the court could provide a remedy, to setting aside a result where the result of alleged malfeasance is itself unknown. In cases, for instance, a proportionality method has been utilized. It has been a remedy for a known number of illegal votes cast in an unknown proportion to candidates. But elections are decided by votes, not by polling responses, and the court has found no authority suggesting that election polling ought to be used in this manner. Given the election polling is done after the vote has been cast, the weight of authority seems contrary to this proposition. Indeed, to the extent that the range of outcomes was suggested by Ms. Barrett, he suggested that with its expected turnout increase on election day of 25,000 to 40,000 votes, the outcome could be between 2,000 vote margin for Hobbs to a 4,000 vote margin for plaintiff. He did testify to that. Taking Mr. Barris's claims at face value, this does not nearly approach the degree of precision that would provide clear and convincing evidence the result did change the result of the election as a result of the failures. While this court, in absence of controlling authority, is reticent to state that statistical evidence is always insufficient as a matter of law to demonstrate a direct effect on the outcome of an election, a statistical analysis that shows the current winner had a good chance of winning anyway is decidedly insufficient, which, fair enough. Negligence is doing reasonable but best, still failing. Recklessness, aware of substantial risk. It's not bad. Economouth, yeah. Further, Mr. Barris cannot say, and further, there is no evidence at trial that these voters were turned away or refused a ballot. These voters who were not elected to vote, whether at a center, due to long lines or media coverage of chaos on election day, or any other number of reasons, none of these constitutes a direct effect permitting the court's intervention as outlined in prior cases. Mr. Barris's testimony does not show by clear and convincing evidence the alleged misconduct influenced the election. Barkey says, so smoking gun theory doesn't apply? Well, even a smoking gun doesn't necessarily imply intentionality. As I'm sure we're all aware, negligent discharges do happen. So a smoking gun is evidence the gun fired. Strictly speaking, it's not even evidence of criminality because people can shoot guns legally. So smoking gun is evidence a gun has been fired. It does not necessarily imply intent, and it does not necessarily imply illegality. So yeah, the analogy kind of breaks down a little bit. The court makes the following observation about plaintiff's observations, or plaintiff's case. Every one of plaintiff's witnesses, and for that matter, defendant's witnesses as well, was asked about any personal knowledge of both intentional misconduct and intentional misconduct directed to impact the election. Every single witness before the court disclaimed any personal knowledge of such misconduct. The court cannot accept speculation or conjecture in place of clear and convincing evidence. That's basically the bottom line right there. If you want sort of the bottom line, that's the bottom line, right? The court cannot accept speculation or conjecture in face of clear and convincing evidence. That's the bottom line. The closest plaintiff came to making an argument for quantifiable changes resulting from misconduct was Miss Marie's affidavit as discussed by Miss Honey. Again, she states that Runbeck, election services employees, were permitted to introduce about 50 ballots of family members into the stream. But even this is not sufficient. Such a claim, if the court accepted the affidavit at face value, would constitute misconduct, but would not come close to clear and convincing evidence that the outcome itself was infected, because it's 50 ballots, right? So that would be a problem, but not enough problem to change it. Though again, weighing the affidavit against other testimony, the court doesn't even give it that much weight. Which is fair enough, because the court is the finder of fact. And so it's like, well, if I accept it at face value, it's still only 50 ballots. And I'm not accepting it at face value either, because of other testimony. So, okay. People failed to provide. So the judge ignored eyewitness affidavits. No, Roland, the judge didn't ignore. The judge is weighing. That's what they're doing. The judge is the finder of fact in this situation, because this is a hearing. The judge is weighing the evidence. He's not ignoring it. He's weighing it. He's got some witnesses who say one thing. He's got some witnesses who say another thing, and he's weighing. He's weighing the evidence as the finder of fact. It's like, okay, do I believe these people or do I believe these people? And it doesn't hurt in any particular way that the law requires the benefit of the doubt be given to the election officials. The law requires that they be given the presumption. And so his weighing of the evidence seems quite reasonable to me, given those standards. He's saying, this is how I weigh it. I've got some evidence. This is how I'm weighing it. Okay. I mean, that's one of the things that the finder of fact does. And it's a very reasonable way to weigh it, in my estimation. Plaintiff failed to provide enough evidence to which this court could find her on either count by clear and convincing. To the extent certain claims are contradicted by defendant's case in chief, it's unnecessary to go into detail, but a few points are worth knowing. So, yeah, the plaintiff doesn't prove their case, so I can just stop. So, to the extent defendant contradicts their case, I don't really have to talk about it, but I'll talk about it a little bit anyway. Thoughts on appeal? No chance in hell. No chance in appeal. No chance in hell. As to Ray Valenzuela, co-director of elections for Maricopa County Recorder Office, testified. Not for the least of reasons, incidentally. That as the finder of fact, he is subject to clear error. Which, good fucking luck. None of this even looks remotely like clear error. He is looking at the witnesses and he's weighing them in a very reasonable way. It's up to the finder of fact to weigh them. So basically, his findings as finder of fact are completely unattackable on appeal. To attack the finder of facts, findings of fact on appeal, you have to show clear error. You have to show it's against the manifest weight of the evidence, which no. So his findings of fact are completely unattackable. And given these findings of fact, there's no goddamn way you can win on the law. So it's over. It's over. I mean, not to put too fine a point on it, but the finder of fact has spoken. So these are facts now. Right? That's what the finder of fact does, whether it's a jury or a judge. The finder of facts finds facts. And so these are facts now. Reality has been defined. It could be this or it could be this. It's this. So it's this, not that. That's what the finder of fact does. These are facts now. Yeah. Found facts and truth can be different. Fair enough, but fair enough. Juries make mistakes sometimes. Judges make mistakes sometimes, but but it doesn't really get you anywhere. So is it true? I don't know. It's a fact though. As Ray Valenzuela of the Maricopa County Recorder's Office testified no direction or permission was given to Maricopa County to run back to allow its employees to submit ballots in any manner other than authorized to the general public. He, Mr. Scott Jarrett, also co-director, and Mr. Stephen Richard, county recorder, each testified that Maricopa County election workers are trained to follow the EPM, and to their knowledge, this was done. As noted above, both Mr. Vanzuela and Mr. Jarrett testified that Maricopa County employees were observing the ballots at each stage of process. Plaintiff brought forward no evidence sufficient to contradict this testimony. It bears mentioning that election workers themselves were tested by both plaintiff's witnesses and defendant's witnesses as being directed to perform in their roles with integrity, not perfectly, as no system on earth is perfect, but more than sufficient to comply with the law and conduct a valid election. Considering all the evidence found, the court finds as follows. So here are some findings. As to count 2, the court does not find clear and convincing evidence of misconduct in violation of law. The court does not find clear and convincing evidence that such misconduct was committed by an officer making or participating in canvass. The court does not find clear and convincing evidence that such misconduct was intended to affect the result. The court does not find clear and convincing evidence that such misconduct did in fact affect the results. Those are facts now. The court does not find clear and convincing evidence of misconduct. The court does not find by clear and convincing evidence that such misconduct was committed by an officer participating in a canvass. The court does not find clear and convincing evidence that such misconduct was intended to affect the result. The court does not find by clear and convincing evidence that such misconduct did in fact affect the results. Yeah. I know you guys don't always like it when I have to give you. Now, for the record, by the way, I would have preferred Keri Lake to be elected. But then, of course, I, being a good lawyer, have to give good legal analysis, right? And I know some of you may be displeased by this, but I find this court's legal analysis to be correct. This is the state of the law. I believe the court has properly stated the law. I believe the court has properly stated what the witnesses are. I believe the court's findings as to what witnesses are believable or not, in the respects they're believable and not, is reasonable. I believe this court has engaged in its function properly. I believe that this is a correct legal decision. I know that doesn't make everyone happy, but I can find no fault with it. I can find no error with it. So, we can't always get what we want, I suppose. And maybe the law should be changed. I don't know. Right? If we're going to have a policy discussion as to what the law should be, which incidentally, you guys got me on a distraction earlier with a whole policy discussion about, okay, what should the standard be? And then we got into a policy discussion for a while. And your policies kind of sucked because you weren't thinking them through, because they were very easily attackable. It's like, oh, this should be the standard. Okay, if that's the standard, here's what would happen. All right. So, if we're going to have a policy discussion, we got to think that all the way through. So maybe the law should change. I don't know. But given the state of the law, this is correct. Our judicial system is broken and we're now in a third world country. I couldn't disagree more, Tori. I couldn't disagree more. Judges have to judge based on the state of the law. Justice is blind. Justice is blind. She has a blindfold on and scales in her hand. And she assesses neutrally. And she weighs. And I think that this is a testament to the judicial system, not a rebuke of it. But that's me. Therefore, it's ordered that Katie Hobbs is the Arizona governor-elect. The court notes the representation of county defendants that motion for sanctions would be forthcoming. And court also considers the need of the court to enter an order under Rule 54, Arizona Rules of Civil Procedure, that all appeals on issues might be taken in timely fashion. Therefore, statement of costs, including compensation, must be filed, and any motion for sanctions must be filed by this date. After assessment of sanctions or failure to file, the court will enter a signed judgment. I don't know that there's any sanctionable conduct here. There wouldn't be under the federal rules. I can't imagine there's under Arizona state specific rules. So they might seek sanctions, but I don't think there's any sanctionable conduct here. Not that I can see. It just didn't work. Just because it doesn't work doesn't mean the attorneys are sanctionable. So that's basically that. That's basically that. Yeah. And so, that's the right legal decision. So there's zero chance on appeal. There's zero chance on appeal. Because you can never get past the judge's findings of fact. It's impossible. Can't be done. Not here. Like the only times you're going to find attacking the facts is clear error. And one of the ways you can do that is manifest way of the evidence. And the manifest way of the evidence. And when you're thinking manifest, you're thinking the scales are really lopsided, by the way. Because the jury is entitled to disregard, or the finder of fact for that matter, whoever it happens to be. The jury or the finder of fact is entitled to disregard evidence that weighs in the majority. So they're the ones that weigh, and they're allowed to say, well, the majority of evidence is one way, but we think the minority of evidence, right? Because of reasons, right? As long as those reasons make any logical sense, there are reasons the majority of evidence, there's a lot of different ways to weigh a majority. But if one way of thinking about it easily would be, let's suppose that one side has 2 eyewitnesses and one side has 1 eyewitness, right? And the one side, both their eyewitnesses testify consistently, and the other eyewitness testifies opposite. All right. So you got 2 people who are eyewitnesses who tell one story, and you got one person who's an eyewitness who tells a different story. Okay. Without me telling you anything more, is it inherently unreasonable for the jury to believe the one person over the 2? And of course, the answer is no. Of course, the answer is no. There are any number of reasons the one person might be more believable than the 2. Right? Maybe the 2 have suspect characters. Maybe the 2 didn't have as good a vantage point. Maybe the 2 have a bias in some way. Maybe the one has some sort of special training in some way that makes them a better witness. Or any other number of things that you could create in your mind. Like, why does the jury believe this one person over these 2 people? It shouldn't be too hard to think of some possibilities, right? So even if the jury, and it could be 5 versus 1, right? And we could still do the same kind of thing. 5 witnesses testify the same and one person testified the other way. The jury believes the 1 over the 5. Is that inherently, without knowing anything more, unreasonable? No, of course not. There might be reasons why the one person, on balance, wins over the 5. There might be reasons for a jury to draw that conclusion. So when you're thinking manifest way of the evidence, it has to be pretty manifest, right? It has to be pretty manifest. It's like, okay, it's the videotape and the DNA and the eyewitnesses and the confession, and we're going to disbelieve it all, in favor of the other guy. It's like at some point, it's like, I'm not sure how you're getting there, but you're allowed to believe against the lopsided suggestion. And here, I don't even think we're there. We're not against the lopsided suggestion. We're not. I think the court's analysis is quite balanced. So, yeah. So that's what I think about the state of the law. That's what I think about the state of the law. You're assuming they can see? Yeah, there you go. See, right? Yeah, I didn't tell you anything about the eyewitnesses. I didn't tell you jack shit about them. Would it surprise you to learn that 2 eyewitnesses to testify consistently are also blind? Yeah, absolutely. I hadn't tell you anything about them. All I told you was that there were 2 eyewitnesses who testified one way and 1 eyewitness who testified another way. Maybe the 2 eyewitnesses are blind, which makes them kind of lousy as eyewitnesses. Could be. Yeah. Paco Fonzi says, keep being smug about cases that make society crumble. I don't know what to do other than do legal analysis, my guys. I don't know what to do about other than legal analysis. What do you want from me? What do you want from me? What do you want me to do other than do legal analysis? Like, what do you want me to do? What do you want me to do? All I can really do is legal analysis. That's my skill set. I'm good at it. I'd like to think I have a lot of knowledge to bring to bear. What more can I do other than provide legal analysis? And be like, yeah, this is good legal analysis. I agree. Like, what do you want from me? Quit making excuses for crooked judges? Oh my God. Oh my God, you're impossible. You're perfectly okay knocking down Kagan. Sometimes I agree with Kagan too. Sometimes I agree with Sotomayor. Sotomayor, I agreed with one time in an 8-1. Right? Sotomayor is not my favorite justice by any means, but she was the sole dissent in this case called Kansas v. Glover. 8-1. She wrote the one-person minority decision. I agreed with Sotomayor. I thought she was right. I thought the other 8 were wrong. Sometimes I think Kagan's right. I don't agree or disagree. And for that matter, sometimes I disagree with Justice Gorsuch. Sometimes I disagree with Justice Thomas. Sometimes I disagree with Alito. You know, sometimes I agree with their legal analysis and sometimes I disagree with their legal analysis. Why can't I do it for this judge? Because I agree with his legal analysis. I just think it's the correct legal analysis. I don't know what else to do. I don't know what else to do except to say, okay, I think Justice Kagan was right here. She asked this. I think this is a great question. I even was praising Justice Jackson the other day in some hearing. I forget what hearing it was, but Justice Jackson was asking questions, and I'm like, yes, Justice Jackson, that is the correct question. That is a smart and observant question, Justice Jackson. I'm glad you asked it. I think your thinking is correct on this matter, Justice Jackson. Not because I'm a fan of Justice Jackson, because I thought she was right. If you watch the trial, you know you're wrong. I did watch the trial. Not all of it, but I watched a lot of it. I was on with Andrew at Law Self-Defense. I watched a significant amount of it. I watched the expert testimony from the guy who, I watched the principal expert from, where was he from? Some polling organization. Are you familiar with 538? Yes, they're our competitor. I think they're garbage. So yeah, I watched a significant amount of the trial. I still think the judge was right. So, yeah, that's my thing. The judge's whispering was a bit annoying. That's true. I wish the judge had projected a little bit more. That's fine. Yes. Yeah. Let me read your super chats. That's a good reminder, JT Brown. While I see your super chat come in, let me read the other super chats that came in along the way. Okay, your super chats today. Z Comer, ZZZ, gave NOK 100 to say never give up. Don't worry. I'm never going to give you up. Never going to let you down. Never going to turn around and desert you. A Capitan gave $1.99 to say Merry Christmas. Well, Merry Christmas to you as well. James Fuller gave $2. Andrew Gibbons gave $20. Thank you very much. To say Merry Christmas, Kurt. Well, Merry Christmas to you as well. Rain Man YYC said for $2 Canadian, there's an option to start a recall in 6 months. Okay. Cranky Paperclip said Lake would have needed emails from county personnel expressing intent to do the things. That would help. Or someone overhearing a conversation. Or, yeah, that would have helped. Something like that, yes. Freddie York gave $9.99 to say with 12,000 different ballot definitions. It isn't necessarily that all the ballots be misprinted, and the sample size was tiny, just a few ballots missized, would result in madness. Gook Naba gave $1.99, says it's Gooch, by the way. Thank you, Gook. Lol. Economath gave $5 to say negligence, doing a reasonable thing best, but still failing, reckless, aware of substantial risk, that certain result will occur as a result of actions. Not a bad definition. Economath says facts found. This is our life now. Thank you. Go Ho Shane for your memberships. SH gave $5 to say, how can Keri's team get more info now on the 19-inch ballot issue to see if there in fact was misconduct? Can the Arizona Attorney General jump in with an investigation? It's far too late to do anything practical. I suppose the Attorney General probably can jump in, and you might be able to get to criminality. I mean, that would be your remedy at this point, but the governor's going to be governor. So, Nicholas Starro, union rep, labor law, says bad laws you don't want the opposing side to use. With good laws, it doesn't matter. Same with judicial systems. Just because you don't agree with the judgment doesn't make the system broken. Exactly so. JT Brown says the voting system we have won't change until Republicans get in power to change it. Therefore, they need to accept the system that we have. Harvesting, ballot canvassing exists as permissible. Liz Botts said $4.99. Been mean to ask, are you a trans singer? I did a little bit of choir when I was in middle school and high school, but that was a long time ago. But you know. And Danielle Vargas said, is Lake on the hook now for any legal fees? I don't know about the fee shifting statutes that exist. My guess is no, but I don't know that. Apparently, the state of Arizona wants to file something for sanctions, but I don't see sanctionable conduct by the attorney. Although there might be some fees that aren't strictly speaking legal fees, because I think she might have to pay for like some of the canvassers or something. I think because of the nature of the challenge, I think there's some fees incurred. So she'd have to pay those fees. But those fees were kind of due no matter what happened, as my understanding. So there might be some money, but I don't think strictly speaking legal fees, no. So that's why it should have been a jury trial. No time. Time was a major factor. And yeah, I think this is not an issue that's normally triable by a jury. This wouldn't be triable by a jury at common law, so the trial by jury guarantee wouldn't apply. Shriblogi says, I don't agree with your politics, but you're the only YouTube lawyer, except for the female whose name escapes me, that I watch. I think you have a gift and you share it without being crude or crass. Well, thank you. I try. I just try to be reasonable in the literal sense of the word reasonable. Reasoned. I try to be reasoned and just try to walk things through in a reasoned way, in a logical chain of reason. Reason is our guide, right? And so, like, well, if reason is our guide, let's follow it through. And, like, you know, well, this is the correct result. So, thank you. I do my best. I do my best, and I appreciate it. Well, I suppose that's all then. Should we do something completely different? I don't know that I'm really in the mood for something completely different right now. I think maybe do I address the accusation of perjury? Prove it. Prove it. Prove perjury. Good luck. For your information, the judge was Republican. Doesn't surprise me in any way. This is a very judicially conservative decision. It tracks my legal thinking completely. This is how I think you should think as a judge. This is the correct way of thinking, as far as I'm concerned. Not my preferred writing style. You know, it's a little bit too. What would you say? It's a little bit too sterile for my taste. But I think his reasoning is on point. Do I want to become a judge? Yeah, I think becoming a judge would be cool. I think becoming a judge would be cool. But if you appoint me judge and you're expecting anything else other than this as a result, well, you'll be disappointed. I'll do my job as a judge. I will be I will be a good conservative, originalist, textualist, constrained, judge. So, all those things. This is the correct way of thinking. We're a banana republic. I don't know what to tell you about that. I don't know. The alternative seems to be judicial activism, and that seems like a bad plan. What's the law on voter fraud? It's pretty broad. I mean, but basically just like, voting when you're not supposed to, basically. Yeah. I'm going to sign off. Well, my friends, I will wish you a very Merry Christmas. I hope you're having a fantastic Christmas Eve. And I hope that some of you are with friends or family or will be in the coming days and have a chance to spend some time enjoying company and being one with those who are near and dear to you. And I hope all of you out there are keeping warm as well, because it's very, very cold out there. It's cold out there today. It's cold out there every day. And I hope that you get some cool stuff from Santa. I hope he leaves you something under your tree that you were looking for. I am simply looking for your like as my Christmas gift. So if you'd be so kind as to hit the like video channel. And if you want to drop a super chat or PayPal or something on the way too, as a little bit of Christmas gift, well, I of course won't say no. You can do that by clicking the join button, or you can just go to paypal.me/uncivil-law or whatever. If you want to contribute to the channel and help us grow, I appreciate everyone. I appreciate all of you who are here. I love you all. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.